And there's Mr. Burns. Mr. Burns, there you go. Far more impressive than the cameras we have in our monitors here. All right, counsel, you may proceed.
May it please the court, my name is Guy Burns. I represent the appellants of Vein and Vascular Institute, and often referred to throughout these proceedings as the Vein Clinic. The appellee is Mark Gockenauer, and this case is about what is either a misunderstanding or a clerical error regarding $166.24 that has been fully refunded to the appellant, Mr. Gockenauer, in 2016. There are no damages in this case, and that will be a recurring theme in my argument. For several years prior to Mr. Gockenauer—
Mr. Burns, do you want to reserve any time for rebuttal?
I would reserve a couple of minutes.
Very good. I'll let you know when you get to 3 minutes, and then you can use it as you see fit.
The court in this case issued a summary judgment on all 5 counts of a 5-count complaint, 2 FDUPTA counts, a Florida Consumer Collection Practices Act count, a count for unjust enrichment, and a count for restitution. In none of those counts did the court find or award any actual damages. The only monetary award is a $1,000 award under the statutory provisions of the Florida Consumer Collection Practices Act, which we contend that was an error, and there's been no violation of that act. But there was no proof offered as to any actual damages, and no actual damages were awarded, including even though a judgment seems to be rendered under unjust enrichment and restitution, there is no number that's awarded for the amount of the unjust enrichment or the amount of the restitution. And under the FDUPTA case count, there's no damage award of any specific amount. And therefore, anything, the whole case should fail because of that. For several years prior to 2015, the Vein Clinic advertised a free consultation practice. That is, if people called on the telephone to make an appointment and identified an advertisement or publication where they saw a free consultation being offered, they could book a free consultation. Mr. Gockenauer had an appointment on December 15, 2015. He contends he made an appointment for a free consultation. The records of the Vein Clinic do not show that he was booked as a free consult. And so when he completed his consultation that day, a billing was sent to Florida Blue Cross Blue Shield, often referred to as Florida Blue, his insurance company. And so in looking at the period of time for which computer records are available over approximately 4 years, the Vein and Vascular Clinic saw about 9,546 new patients. Of those, 1,256 were free consults, and 8,290 were booked as paying patients. And these are for people coming in for the first time. An audit, using that term not in a classic CPA sense, but an audit or review of all the billing was done, and of the Mr. Gockenauer would be included in the 8,290 people that presented as at least the records reflect as a paying patient. For those 8,290 patients, the clinic discovered that in the past several years, 12 people had, in addition to Mr. Gockenauer, had asserted that they were being billed for a free consultation. In each one of those other 12 instances, the patient was immediately, the bill was either canceled, or if there was any insurance or other payment made, it was immediately refunded. So Mr. Gockenauer is the only person among nearly 10,000 people who asserts a claim that he was booked as a free patient and did not get a refund or cancellation of his bill. When the bill was submitted to Florida Blue, initially the insurance company denied coverage as a pre-existing condition because Mr. Gockenauer had a prior automobile accident that involved some vascular damage and vascular surgery. So no billing was sent until after that denial of coverage. The first bill was sent to Mr. Gockenauer by the Vein Clinic for $166.24 on March the 2nd of 2016. That bill stated on the lower left-hand corner, a computer-generated message that said, "Your prompt payment is greatly appreciated." Toward the end of the month of May, on May 25th, 2016, a second billing was sent that says, "Your account will be considered for collection if no payment in 10 days. The Vein Clinic never made any collection-related phone calls, never made any other collection-related efforts, collection-related actions against Mr. Gockenauer, never reported him to any credit rating or collection agency, and the Vein Clinic has a policy of not undertaking any collection efforts directed toward patients." So the total thing that they did was to send 2 invoices. Florida Blue eventually reversed its initial denial of coverage, and my client participated in an appellate process on that. And on June the 6th of 2016, Florida Blue sent a letter to Mr. Gockenauer stating that after reviewing his appeal, which my client prosecuted, the Florida Blue had reversed the denial of coverage and was going to pay $90.23. And Mr. Gockenauer would be responsible for the balance, which turns out to be $76.01. So Mr. Gockenauer knew on June the 6th of 2016 that he did not owe the $166. Nonetheless, Mr. Gockenauer, who was working with an attorney, had an attorney draft a letter on his behalf and sign Mr. Gockenauer's name. So the letter does not appear on lawyer letterhead, and it remitted $166.24 to the Vein and Vascular Clinic, or to the billing agency that they retained. So Mr. Gockenauer, at the time he mailed in his $166.24, knew that was the wrong amount. He knew it was an overstated amount. It was more than double what on his worst day he owed. And when that check was received, the billing agency on July the 28th, 2016, and I'll make a correction of our brief. We have a typo that said that was July 28th, 2018. That's on page 6. It's really July 28th, 2016. They contacted Mr. Gockenauer, the billing agency, and said, "Do you want us to mail your check back to you? You sent us a check. It's no longer the right amount. Should we send it back to you?" Mr. Gockenauer refused. He said, "No, go ahead and cash the check." So they did, and they immediately paid him $90.23, which was the amount paid by his insurance carrier on his behalf, reducing his balance due to the $76.01. Thereafter, Mr. Gockenauer filed this lawsuit seeking class certification and contending that he had been improperly billed for the $166. So instead of accepting the return of his uncashed check, he decided he wanted to sue in a class action. After 3.5 years, he could identify no other person who had been among the 10,000 patients at the Vein and Vascular Clinic who were first-time patients who had been had a supposed free consultation for which they had paid. So he was all alone, and he dropped his class action allegations, but proceeded as an individual. And at the time he filed suit, within a week or two, the Vein Clinic refunded to him his $74.01. So as of October of 2016, he has tendered an improperly and overstated check. He has refused the return of his check, and he has refused to cash 2 checks, which in total amount to $166.24. So he's been made whole every way that my client could make him whole, but he has proceeded with this case. And he contends that
Mr. Burns, I just want to clarify one thing. You said his check was basically an overpayment, but that was the amount that was being sought by your client originally, correct?
it was the amount of the invoice, but between the time of his final invoice in late May and his check on July the 12th, he had received notice from Florida Blue, that they had honored his appeal and that he no longer owed $166. He owed a lesser amount. And
Okay, but your client still claimed he owed money.
My client would have had his adjusted bill there at $76.01. He mailed in $166. So they immediately called him and said, "Do you want us to send your check back to you? It's in the wrong amount." He says, "No, don't send the check back. Go ahead and cash it." So they cashed it and immediately sent him $90.23, which was the amount they'd received from Florida Blue. Then,
Okay, I just wanted to make sure that you were not contending that he had been told he didn't owe anything and he sent the check in. Your
Yeah.
client still believed it was entitled to some money.
my client had a good faith belief that there was money still owed. He filed this class action lawsuit in September, and within the time for answering the complaint, they tendered to him the balance of the $74.01,
Right.
or saying basically, this is not, or $76.01, it's not worth fighting over. We made a business decision. Let's just give the money back and all move on. Well, that's been now 7.5 years ago, and Mr. Gockenauer doesn't want to move on. So there was, because there was no evidence of actual damages, and the court in its judgment found no actual damages because no evidence had been proffered, the damages that the court assessed was the $1,000 statutory, up to $1,000 statutory penalty provided in the Florida Consumer Collection Practices Act. And that specifically is not tethered to any actual damage amount that might have been suffered by a debtor.
And once the lawsuit had been filed, your client was on notice that it would potentially be liable, at least in that minimum statutory amount, correct?
If they had violated the statute, and they had not. So
yes. I understand that's your argument, but they never, at least on this record, they never tendered the $1,000 to cover the statutory damages that he might have been entitled to if he prevailed.
That's correct, and they didn't believe that they had violated the the Florida Correcting Practices Act, and they didn't tender the $1,000, but they tendered all of his money back to him. So
did they tender any interest with that for the time period that they had his money?
No, and
was it pled?
They apparently had this extra $70-some for a period of about 3 months, and so
it's about $1.50, wasn't it?
Pardon me?
The interest was about $1.50, wasn't it?
I have not calculated it, but that sounds high to me. So in any event, the court initially ruled that there had been a violation of the Collection Practices Act, and that and so they made an award. He made an award of summary judgment on that. He had this springing judgment thing that if that was affirmed on appeal or became final, then the other counts would go away. But if the debt collection practices claim did not become final, then those other counts would spring back to life. We felt we had an obligation to appeal. We did. The appellate court said, no, this is not a final order. And so he then issued a final summary judgment as to all counts, which brings us here. And in the final summary judgment action, the judge specifically recognizes that for FDUCTA, and this is in his paragraph 6, that the plaintiff has suffered a loss as a result of the FDUCTA violation. There was no FDUPTA violation. This was a clerical error or a booking mistake that has been blown totally out of proportion. It does not constitute a deceptive and unfair trade practices act. This is one patient out of nearly 10,000 that finds themselves in this circumstance. So then we turn ourselves to the $1,000, the count 3, which is the Collection Practices Act count. I think that there is no evidence, and I believe that essentially Mr. Gockenauer would concede that there was no abusive collection practices here. He received 2 invoices, no telephone calls, no credit agency reports, no nothing. So they are saying that the claim it falls under section 559.729, which says that it's a claim, an attempt to collect an illegitimate debt is an abusive collection practice. And there's 3 elements to that. One, it has to be an illegitimate debt. There's a substantial issue of material fact regarding whether this is an illegitimate debt, whether he did book, as he claims,
Well, the problem, of course, here, Mr. Burns, is the fact that the clinic advertised these free consultations. He came in to get one. They took his insurance card. They hid his insurance. They billed him twice. And then they stonewalled him. They jerked him around. They stonewalled him. He tried to get it straight, and he couldn't get people to respond to him. And unfortunately, after a while, he just kind of said, I give up. These people are jerking me around. And he went to a lawyer, and here we are. But the question really is whether or not it was an illegitimate debt. Well, if they're advertising a free consultation and he shows up to get one and they hit his insurance, it's probably an illegitimate debt. Okay.
Well, first we have to start with that premise. The practice of the clinic, and there's an email that talks about it, and then their testimony has been, if you have seen one of these ads, it's not any different than if you want a free pizza. You see an ad that says call and say I saw the ad and I want my free pizza, or I want my free this, that, or the other. And so they say they don't do any online appointments. You call and the desk.
Was there anything in the ad that put people on notice that they had to specifically, when they showed up, they had to indicate they saw the ad? Or is this just sort of a game that was being played?
Well, I don't think it was a game being played, but I don't recall any ads that said call. It said call for a free consultation. It didn't say call and mention this ad, but it said call for a free consultation.
Well, it sounds like a game then. It sounds like they're putting out this big ad to get new clients in, thinking they're going to get a free consultation. And if the clients don't say the magic words when they get there, all of a sudden their insurance gets billed. And, unfortunately, a lot of people take the position that, well, my insurance got billed. That's not me. I don't really care. We kind of know how that works. So only a few of them actually complained when they had a partial pay or a copay. Well, I appreciate what you're trying to tell us, but your client doesn't look completely innocent. Your client looks like they're playing a game.
I take exception with that because out of 10,000, nearly 10,000 people, we only had 12 people who said, wait a minute. And so the intake people are trained to say, how did you hear about us? Well, you saw an ad, and they have a conversation that would have the person say, I saw an ad for free consultation, or make some statement to that effect.
Mr. Burns, Mr. Burns, wasn't there evidence by Mr. Gockenauer that in fact he asked for a free consultation?
He says he asked for one. And what we have is evidence of the people who are at the intake process. So whenever anybody asks for one,
did any person who is involved in the intake provide an affidavit refuting his testimony or his affidavit?
No, we don't know.
So there's no genuine issue of fact disputing his testimony, other than your contention that, well, our normal business practice is this, and this is what's supposed to happen. But that was not someone who was involved with him when he says, I did ask for my free consultation. That's why I went in there.
Correct, but let's remember this, that he said he asked for the free consultation. We didn't report him as a free consult. So what we have is not a deceptive practice. What we have is somebody who maybe booked him under his best scenario. They booked him as a paying patient when they should have booked him as a free patient. And at the end of the day, when his check arrived, they called him and said, "We want to send you your check back." He said, "No, cash my check." And then, you know, so that's, and if.
And Mr. Burns, if you want to, Mr. Burns, if you want to reserve your 2 minutes for rebuttal, you're there now.
All right, thank you. I'll go ahead and reserve.
Thank you. Mr. Caldevilla?
May it please the court. Good morning, your honors. I'm Dave Caldevilla, and I'm representing Mark Gokenauer in this appeal. The defendants have failed to demonstrate any reversible error, and I request the court to affirm the trial court judgment. Let me clarify a couple of things on the questions that were just asked to Mr. Burns and what he just said to the court. He started off by saying that there were about 8,000 new patients that were seen by the defendants who were charged for their initial consultation. I got to say, I was not counsel of record at the trial court levels till 2022. But that's the first time I've ever heard that said in quite that way. I'm kind of surprised by that. He says that my client was one of the 8,000. Now, the record shows there were at least 12 people who complained about it, in addition to my client. And then after my client filed this lawsuit, they quickly paid 6 other people who had requested a free consultation. The other question that came up, Judge Silberman, you asked him about this when Blue Cross Blue Shield paid and whether he knew it. And I don't recall seeing anything in the record that when Blue Cross Blue Shield reversed the denial of the claim, that was on June 6, 2016. And I have a record site of 3740, page 3740 of the record on that reversal. It's a claim denial detail report. It says that they're paying $75 and the client responsibility was $0. So I don't know of any evidence that Mr. Gokenauer was ever provided that. If there is, I'll be willing to stand corrected, but I don't see anywhere in the record that he was sent that. And there's certainly nothing in the record where the defendant sent out a revised bill to him. So the record is that he sent a letter on July 12th, worried that he's trying to finance a new house and worried about getting a loan. He's got this bill saying, if you don't pay it within 10 days, we're sending you to collections. So he paid the $166.24 under protest. And that's crystal clear from the record. There's no evidence that he sent a check knowing that Blue Cross Blue Shield had already paid $75. And Judge Smith, you asked whether the claim for interest was pled. It's pled for every count in every version of the complaint. It's pled in response to an interrogatory question that was asked. I'll give you a citation to that. It's page 2748 of the record. They asked, how come you didn't accept our payment? He says in the interrogatory response, well, you didn't pay me interest. You haven't satisfied my $1,000 statutory claim. And there's other arguments in there as well, that they didn't confess judgment, which is their option. If they wanted to get rid of this suit right off the bat, you file a notice of confession of judgment.
Isn't the interest, de minimis? Isn't it a very small number?
I wouldn't call it de minimis, but by my calculations, and I'm not a math wizard, but I get $1.47. So is it a large amount? No, but at that time, when we filed this lawsuit, Judge Morris, Mr. Gokenauer is entitled to seek $1,000 statutory award, not only for himself, but for the putative class members that he was seeking to represent. And I'm telling you that this is the first time I've ever heard that they're claiming that there was 8,000 people who were charged for their first consultation. I'm surprised at that. I don't recall it ever being presented that way. I think if we were aware of that, the class certification motion would not have been withdrawn. It was withdrawn because we were under the impression that they were ceasing this practice. is what the record says. Again, this is before my time as counsel of record in the case. But yes, there is interest, and it is a small amount. And I'll point also to the final hearing transcript. Mr. Burns says that interest wasn't claimed. It was claimed. It's claimed at least 4 times in the final hearing transcript, which, by the way, that's the only transcript we have, is the final hearing transcript. I'll direct your honor's attention to pages 5272 of the record, 5273 of the record, 5282 through 83 of the record. All those times, Mr. Clark, trial counsel, was arguing, look, there's interest owed here. It's a small amount. It's a nominal amount. But if you award the $1,000, which we're entitled to, that pretty much is going to resolve everything. Now, we can figure out the interest and back it out and award $1,000 or the difference is interest. I forget exactly how he explained it, but the number $1.47 was never mentioned other than, hey, it's a small amount. We all acknowledge that. We're here for the $1,000. That 147 was subsumed by that statutory award, which Mr. Gokenauer is clearly entitled to. So with that backdrop, I just, I wanted to address your honor's questions, but going to Mr. Burns's argument that this was just a clerical error, a miscommunication, there's no record of that. There's no affidavit of that. We went to summary judgment based on Mr. Gokenauer's deposition and his letters and his sworn testimony that he called and asked for a free consultation, that he booked a free consultation. He showed up there, said, I'm here for my free consultation. They asked for his insurance card, which he was surprised about. And they said, oh no, it's just a formality, just a little thing that we do here. Don't worry, you won't be charged. There's no affidavit from the person who was in charge of taking down his appointment that day. And if you look at their computer records, there's no place on that scheduling form to say, did this gentleman ask for a free consultation or not? You look at their advertisements, they say free consultation, call us. Everybody who shows up there for their first visit should get a free consultation under that advertisement. But Mr. Burns says 8,000 people got charged. I'm surprised by that. But in this case, Mr. Gokenauer shows up there. It's made clear to him that nobody's getting charged. He goes in and according to him, a doctor walks in for less than a minute and then starts ordering a battery of tests. So next thing he knows is his insurance company was charged, which he didn't know about that. He gets a bill for $166. In the meantime, we have emails, chains of emails going back and forth between their employees where Mr. Gokenauer has called to complain at least 3 times, written letters, and they're saying, we're going to bill him. We're going to bill him for this. And not only are they just going to bill him for the $151 that Blue Cross Blue Shield says is the allowed amount. We all know that when you're in network, your healthcare insurance provider gets to reduce the amount of the charge under their provider agreements. The Blue Cross Blue Shield said to these folks, we're denying this claim, but the allowed amount is $151. What did they charge him? They charge him $166, and they send him a bill. I'll cite you to the record. Their bill is at page 3586. They tell Mr. Gokenauer that Blue Cross Blue Shield adjusted the $300 by $133.76. Where'd they get that number? That's not true. They bumped up the bill. First they said they were going to give it to him for free. Then they overcharged him beyond what Blue Cross Blue Shield said would have even been appropriate. So, and then we had this smoking gun email from Ms. Kerr that's dated July 26, 2016. This is a date very contemporaneous with what's going on with Mr. Gokenauer. And she says in her email that this should be, that their staff needs to understand that nobody's supposed to get a free consultation, even if the patient gets agitated. and that they should be able to give their services, give good patient care without giving it for free. That's at page 3430 of the record. Where's the mistake or the clerical error? Where's the evidence of that? There's no evidence of that. Certainly not any evidence that any reasonable person would agree with. So we come back to the FCCPA, paragraph 7 of, I'm sorry, section 559.72, subsection 7 says if you willfully engage in conduct which can be reasonably expected to abuse or harass the debtor, you violated the FCCPA. Well, I think if you tell somebody that they're going to get a free consultation and you bill them, you bill their insurance company, and then you complain about it and they say, oh no, we're going to bill them. You look at their emails, they say they're going to bill them. They know what's going on here. They're billing them for something they promised for free. Subsection 9, if you claim a debt that is not legitimate or assert the existence of some other legal right when you know that that right does not exist, you violated the FCCPA. You subjected yourself to $1,000, up to $1,000 in statutory damages. So there's clearly a violation. And then, there's 5 hearings on this FCCPA claim in one form or another, and there's no hearing transcript. How many times have your honors, either as an attorney or as a judge, been to a hearing or read a hearing transcript where one of the parties stipulates to something important, waives something important, or concedes something important? It happens all the time, but yet they haven't presented any of the hearing transcripts except for the final hearing transcript that's there. So I think it's crystal clear that there's an FCCPA violation. We're entitled to up to $1,000 in statutory damages. There can be no dispute on that. With the FDUPTA claims, again, is it unfair or deceptive to advertise that you're going to get a free consultation and then charge the insurance company, and then if the insurance company challenges it, charge them even more than the allowed amount that the insurance company will allow? I think under any definition of unfair or deceptive, you're going to get there. But, I would cite your honors to Judge Morris's rather recent decision a few years ago, Weber versus Bactus. It's not exactly the same, but it's a situation where a patient was requesting copies of their medical records, and the physician's copy vendor charges $1 a page when the statutory rate's 25 cents a page. And Judge Morris, I didn't think had any problem finding that was at least unfair under FDUPTA and was a FDUPTA violation. And, we have 2 types of FDUPTA violations. One is if you violated another consumer protection statute, that's a per se violation of FDUPTA. You can get additional damages under FDUPTA regardless of any other remedy that you're allowed to have. And then there's also an objective standard under FDUPTA. We submit that what they did here violates the FCCPA, so that's a FDUPTA violation. But if it's not, then it's clearly a violation under the objective standard because it's unfair and deceptive. It only has to be either. And the question is whether Mr. Gokenauer was entitled to damages under FDUPTA. Well, a person who suffered a loss is entitled to damages under FDUPTA. The case law is clear that interest is an element of damages. It's not a separate.
Mr. Caldavia, though,
Yes, sir.
one of the key issue in this case is whether or not the appellant was improperly charged, and that appears to be a disputed issue of fact.
I don't know where it's disputed, Judge.
Well, I mean, clearly you take the position that he was improperly charged, and clearly they take the position that it was some kind of mistake or miscommunication.
I don't know where the evidence of that is, Judge. Where is the evidence that they made a mistake? Where is that? There's no evidence of that, and there's no transcripts of that being discussed at any hearing. We have the final hearing transcript, and you know, at that point, we're under the federal standard. At that point in the litigation, the federal standard is there's no metaphysical doubt that's going to create a disputed issue of fact. So, you know, maybe under the Snyder versus Cheatham standard, you know, you get to stretch out inferences beyond reasonable belief and defeat a summary judgment. But that's when you have evidence. I mean, we got emails going back and forth. Should we charge this guy? Yes, charge him. Bill his insurance company. Be ready when the insurance company changes their mind. Be ready to challenge it. And then we got smoking gun emails saying nobody's getting a free consultation here. We're not doing that. So I don't see the mistake. I don't see the evidence of a mistake. There was no mistake. The Blue Cross Blue Shield told them that this was a $151 charge. They charged them $166. Where's the mistake? Where's the person who says, oh, I transposed that number, or oh, I thought it was Aetna. Aetna, we get to charge $160. There's no evidence of that at all, Your Honor, with all due respect. And under the federal standard, you know, we're under what a reasonable jury could find. Would a reasonable jury defeat the motion for summary judgment? And you got to do more than adducing some metaphysical doubt. And I don't even think you have a metaphysical doubt in this case. We have a right to a permanent injunction under both the FCCPA and under FDUPTA. I don't think there's any serious dispute that we're entitled to an injunction to make them stop. They don't like it. The fact that they don't want an injunction that tells them that you're not allowed to charge people when you tell them that you're giving them a free service. They don't want that injunction. They want it to go away. Tells me that that's what they want to continue doing. And that takes us right under the FDUPTA standard, that if you violate FDUPTA, or if you're likely to violate FDUPTA in the future, injunction against you. That's what you
Mr.
get.
Calderia, I want to go back to one aspect of the issue of whether this could be considered a factual issue of mistake. And the question that I have is, at the time Blue Cross says there's no coverage, and later they say, okay, we'll accept it based on the appeal. During those two events, the Vein Institute was already aware that Mr. Gokenauer, your client, was already saying, I came in for a free consultation. Is that right?
Yes, absolutely. And I will say this too, the Blue Cross Blue Shield appeal was by Mr. Gokenauer, as far as I know. I don't know of any appeal in the record by the defendants. If that's in the record, then Mr. Burns will correct me if I'm wrong, I'm sure. But the appeal was by Mr. Gokenauer, and he says, these people are charging for a 45-minute consultation. The guy didn't even see me for a minute. And this is fraud. He uses the words fraud in his challenge. So when Blue Cross Blue Shield later reverses and says we're going to pay $75 on this, that's a mystery. I believe that the Blue Cross Blue Shield corporate rep was deposed, and I apologize for not being able to give you a page citation, and it's been a while since I read it. But my recollection is that corporate rep was scratching their head, wondering why they reversed that charge, but they did it. There's no proof that Mr. Gokenauer ever knew that they did it. And again, the defendants didn't send him a revised bill. Why didn't they send him a revised bill? So I hope that answered your question, Judge Silberman. I think, on the unjust enrichment and restitution counts, again, do I acknowledge that $1.47 is a very small amount? Yes, I do. But you have to take this in the context of the lead count in this case was the FCCPA count. As soon as Mr. Gokenauer filed that lawsuit, the defendants were on notice that he had a $1,000 claim. If you wanted to get rid of that claim, they had to send him the $76. They had to pay interest, which, by the way, was pled multiple times in the complaint. And they had to satisfy his statutory damages. They didn't do that. They could have got rid of the case by filing a proposal of settlement for some number that would have caused Mr. Gokenhour to back down. They didn't do that. So, for these reasons and the reasons in our answer brief, we request this court to affirm. Unless there's any other questions, that's all I have, Your Honors.
Very good. Thank you very much. Mr. Burns, you've got your 2 minutes for rebuttal.
Thank you. The reference to the number of patients, which counsel said he was unaware of, that is in the record at 4650 and through page 4651. There's a recap of that. The June 6th letter that Mr. Gokenhour got from Blue Cross Blue Shields in the record at 3751. The law is clear that to violate the knowing sending out a bill that's illegitimate is first there has to be an illegitimate bill. There has to be a threat to attempt to enforce the bill. Sending an invoice, I don't believe, is sufficient to make a threat. And third, there has to be absolute knowledge that the debt is illegitimate. It's not a should have known standard. It's not an ought to have known standard. It's an actual knowledge standard. And we have cited cases in our brief to that effect that talk about the actual knowledge standard. The lower court relied heavily on Weaver versus Wells Fargo, which is a case where the debtor actually entered into a settlement agreement with Wells Fargo Bank, and then Wells Fargo continued collection activities after they signed an agreement and accepted payment. And the court found that they had actual knowledge because of that agreement. It's a very unique case. In this instance, there's no similar facts. My client has testified they believe the bill was valid. There was record testimony in my client's deposition about their practices and procedures and how they do the intake. Among the thousands of people that are there as new patients include people who were referred by other physicians. It's not just all people who saw a bus go by and made a phone call. They have a very robust practice. She described as having patients that are referred by other physicians. There are everything from varicose veins to thoracic vascular problems, so anyway, to say that everybody who calls is going to automatically be looking for a free consultation that's not the way it was, and that's not what she described in her deposition, which is in the record.
Very good.
So,
Mr. Burns, we have reached the end of the time. So thank you both for the presentation. We appreciate it. You may feel free or please exit